In Massachusetts, a person can be committed, in other words, forced to undergo mandatory alcohol abuse or drug abuse treatment, according to Mass General Law, Chapter 123, Section 35. And these are often called Section 35 hearings. Now, how this plays out is that the person needs to be, in order to be committed, has to have a severe alcohol or drug problem, number one. And number two, the person has to be an imminent threat of harm to either himself or to the community or to one particular person. Right? So there has to be a severe drug use or alcohol use and an imminent threat of harm. Now, an application needs to be made for one of these hearings. In the application, if you go to the statute, it gives a list of all the people who can submit one of these applications. Generally speaking, it's blood relatives, guardians, police officers, physicians. There's a whole list of people who have grounds to file one of these applications. The application is filed with the court, specifying the nature of the substance abuse and the likelihood of harm. A summons is issued and will typically be served on the person by a police officer, and the person will go into court and will receive an attorney for all of the proceedings. He has a right to an attorney. And there will be a hearing. Now, before the hearing, there's going to be a clinician who will want to evaluate this person. And the person has the right to decline the evaluation, which in many cases would be a good idea because the clinician is going to testify in favor of having this person committed. So if the person wants to be committed, if he thinks that that's best for him, then he can go right ahead and speak with the clinician. But if the person does not want to be committed, then it's often a good idea not to talk to the clinician. And refusal to speak with the clinician cannot be used as part of the argument in favor of commitment. So whether this person speaks with the clinician or refuses to speak with the clinician, there will be a hearing that day. You'll go before the judge, and the lawyer for the alleged addict will argue against commitment. If the clinician testifies, the lawyer can cross-examine the clinician, can cross-examine witnesses who are speaking in favor of commitment, and can present evidence against commitment. Now, if the judge orders commitment, there's a whole list of the facilities that will receive this person and essentially take on the role of being the substance abuse counselors. The commitment it can last up to 90 days, and it will periodically be reviewed. And again, the statute states how those reviews will take place. So this is all known as a Section 35 or Section 35 hearing. I've written a blog post with all kinds of links and examples of the application and whatnot. I'll put that in the description below. And if you have any questions, send me an email.